Friday afternoon, and sometimes that's tough to come to a talk. The paper that I'm going to present today is actually connected to two larger projects that I'm currently working on. One that focuses with the Amal Khouri at Guilford College. She and Amal and I are interested in looking at how did the Lebanese government deal with the past abuses, particularly during the Civil War, and how those how it dealt with them, or lack thereof, impacted the relationship between the different communities. Then the second related project, which I'm currently working on, focuses on reparations as a transitional justice tool. For those unfamiliar with transitional justice, this is a new kind of scholarly or relatively new scholarly literature that looks at countries that have either democratized recently or have come out of a conflict, and how does the government deal with the past abuses in those situations. So many scholars, though, have maintained when it comes to reparation that there's a close link between reparations and post-conflict, post-transition, democratization, and reconciliation. However, less academic work have looked at reparation in particular, and even how to implement such programs. So the motivations behind this paper, dealing with reparations in the case of Lebanon 2006 war, stemmed from a professional interest on reparations and the question of who should provide reparations. But more importantly, also stemmed from my observations when I went down after the 2006 war in December, and then ended up spending the whole summer in 2007, is that there were differences of opinion about the reparation process. Certain people coming in from towns in the south, like Al-Khiyam and Ait al-Shab, had a very much more positive opinion about the reparation process, where those inhabitants of the southern Lebanon seem to have a negative opinion. So this raised two important questions for me. First one, what's the traditional reparation model, particularly who pays reparations, as there were many arguments that the Lebanese government shouldn't have been the one to pay out the reparations. And second, why were there differences in the perceptions between those coming in from certain areas in the south versus those that came from suburbs of Beirut. So as Christian said, what I'm going to do today is to analyze the mechanisms or the model that Lebanon used, which is a unique case. And so I want to talk about that case. Why did they adopt the scheme that they did, which I call the adoption scheme? What were the advantages, disadvantages? But also to address this whole idea about what do we do for victims of violations for international humanitarian law when there is no agreement between the warring parties. So in order to do that, I think it's important to try to discuss first, why am I talking about Lebanon, or the situation in Lebanon within a conception of reparations, but also talking about the role of individual rights in reparations, and how I'm going to argue in this paper that reparations and reconstructions and development should be viewed as complementary rather than independent programs, which is right now, when you look at the reparations literature, they don't talk as much to the reconstruction literature and vice versa. So according to the basic principles and guidelines on the rights to remedy and reparation for victims of gross violations of international human rights law and serious violations of international humanitarian law, which was adopted, this is the law that was adopted by the UN General Assembly in 2005. This law, which I refer to as basic principles law, maintains that victims of international humanitarian law, as well as victims of abuses of international human rights law, are entitled to prompt, effective, and efficient reparations. Now, for those that don't know the difference, international humanitarian law, or the violations of international humanitarian law, these are the situations that occur during war. Okay, they're also known as laws of war. So this comprises of the Geneva Convention, the Hague Convention, and other international law agreements that define the responsibilities and duties of states, particularly belligerents, but also neutral states, and also individual actors. And primarily, summing up this whole slew of law literature, or the articles, is that their main component is how do we protect civilians, right? That's it. It goes all the way back to 1949 within the Geneva Convention, after World War II, after the Holocaust. It became more of a desire to protect civilians during combat. And this is the body of law called international humanitarian law. Now, in the laws, the international human rights law, this includes the Universal Declaration. It includes International Covenant on Economic, Social, and cultural rights, and International Covenant on Civil and Political Rights. So these are your rights as a human being on this planet, right? So the right not to be tortured, the right not to be raped. These are considered within this set of law. So reparations to victims in both of these violations to both of these laws were established way before the UN General Assembly resolution in 2005. Scholars have cited cases of reparations all the way back to ancient Greece. So this is not a new phenomena of providing reparations. Even today, more importantly, reparations are seen a vital tool for the success of any transitional justice initiatives. And they are argued to be a mechanism that helps to support coexistence, peaceful coexistence, and restoration of law after a conflict or transition. However, the road to providing them, having them as laws is one thing. How do we provide them, and are they provided is a different question. And so the provisions or providing such reparations has been extremely a bumpy one, and with many issues still unresolved. Traditionally, if you look at reparations, they fell within the rights of international humanitarian law, right? The laws of war. And they often included for individuals who've suffered losses, and they're included as an obligation one state makes to another state after a war and after a peace treaty is signed. So in these cases, the state that carries out the violation is responsible to pay out the victims, but only through the other state, right? So as victims, you then have to go to your state and request a sum, the payments that has been agreed upon, and your state will distribute the money. But this created a major dilemma, right, for reparations, because the interests or the individuals that are being harmed are not at the core of the framework. However, since World War II, as I mentioned, with these laws becoming more and more, we tended to see, in many cases, countries that have begun to give out reparations, even though they may not have been the ones that carried out the crime. Particularly, we saw this in the cases of where the violations occurred domestically, right, where there were violations of international human rights. So we've got cases extending from Canada, you've got Morocco, you've got the United States, Argentina, New Zealand, South Africa. And given this rise in terms of the number of non-governmental organizations and international governmental organizations who are very much interested in post-conflict and in transitional justice, these rights have become more and more at the forefront on the table anytime there's a transition. I know right now one member of the International Center for Transitional Justice has actually just traveled to Tunis and will be traveling to Libya to talk about transitional justice mechanisms and what will be the right tools to use in those two cases, given the past abuses that have or crimes that have occurred. Also, the paying out of reparations are sometimes done not by the government that carried out the crime. If we think about here in the United States, in 1988, the United States Congress authorized President Ronald Reagan to apologize to Japanese Americans for their incarceration during World War II without charges or trials, and actually sanctioned the establishment of a $1.2 billion fund for reparation payments of about $20,000 to each surviving Japanese victim. So demands for reparations, like I mentioned, are becoming more and more dominant, particularly for violations within a certain country. So now, what about violations, right? I just mentioned that the framework, the traditional framework, is state to state. That means when one state goes to war against another state and being provided for the other state. The problem with that is we see less and less reparations paid out in those scenarios. There are some cases that we all know about, but it's not as dominant or hasn't become as dominant as violations that occur, human rights violations. Yet, despite the fact that if we think about the violations themselves, they could be quite similar, or the impact is quite similar. And yet reparations are extremely important for individuals who have been victims of international humanitarian law. Because if you think about this group, this is a very vulnerable group. They may need long-term medical care. They may need to be able to earn, they may no longer be able to earn an income. They have lost their homes, their belongings. I mean, they just survived a war. And in many of these cases, it's difficult to just, particularly when their rights were violated as civilians, to just start and forget everything that happened and just to start off, particularly in the cases where there's medical care needed. So as a result of this, many have argued, why? Why do we have in some scenarios where we're seeing domestic rights being paid off, but in cases where it's state to state, we're seeing less likely payments? And part of the problem is that has impacted this situation is due to the fact that while the law recognizes as individuals you do have that right, however, when it comes to implementation, you need states, right? You need the states themselves to agree upon this through the peace treaty. And you're less likely going to see that. And that's a huge problem here. And so only states, right, can invoke that right, not the individuals, right? Yes, you may have been, the right is for you, but you don't have the right to invoke the need to have reparations paid out to you. So given the fact that the traditional framework has been dominated by interstate reparations with little focus on individual harms and compensation, this has really created dilemmas for situations where the violations of international humanitarian law have taken place, but where there's no recursive actions for the individuals, for the victims. So this poses extremely important questions. What are the individual victims to do in such scenarios, right? When you either have the government that has carried out the violations not recognizing that they carried out the violations, or what if they're not capable? What if after the war they're completely devastated, right? The whole state has collapsed. I mean, what do you do in those scenarios? Or simply they refuse to compensate. Who's going to force these states to provide the compensation for the victims? Also, if you are the state in which your victims have been, or your citizens have been the victims of international humanitarian law violations, what are your duties to your own citizens? Now, in this paper, we argue that two relatively new cases actually challenge the traditional state-to-state framework. The first one is the compensation after the Iraq-Kuwait War in 1991, and the second one is the 9/11 reparations in the United States. So to start off with the first, the Iraq-Kuwait situation, after the defeat of Iraq in 1991, the international coalition of forces, the UN Security Council, passed Resolution 692, which actually established a compensation fund, and the United Nations Compensation Commission, UNCC, as a subsidiary organ to process claims and to pay monetary compensations for losses incurred during Iraq's invasion and occupation of Kuwait, including violations of both human rights and international humanitarian law. So this is, the UNCC is completely a departure from the state-to-state model framework and incorporated actually innovative elements and procedures in providing compensations to the victims of the war. A major novelty was the priority policy. In fact, what they did is they prioritized the victims, the individuals, not the state and not the corporation, which has tended to be more dominant. In fact, individual claims were on the top 4 categories of the 6-category claim scale, which they had developed. Priority was given to individuals that were displaced, followed by those that were seriously injured or where a spouse and child was killed during the war, then individuals who lost personal property or income. Now, this clearly demonstrates the possibility of individual claims to take precedent over states and over cooperations. So again, while the traditional framework is still dominant, there has been an increasing shift to recognize the right of individuals and their right to reparations, not only under human rights law, but also under international humanitarian law. The second case that I'm going to discuss brings to light not only the rights of individual, but also the deviation from the expectation that the perpetrator model of compensation is the only one available to states whose citizens have been the victims. The idea of a perpetrator model is since the person that carried out the violation should be the one that pays out the compensation, okay? So this has been the traditional, again, part of the model. But on September 22nd, 2001, 11 days after the horrific attacks, the United States Congress enacted Public Law 107-42, the Air Transportation Safety and System Stabilization Act, which called for the establishment of the September 11th Compensation Fund of 2001, which roughly set $4 billion aside. The main purpose of this fund was to provide compensation to any individual or personal representative of an individual who was killed or physically injured as a result of the aircraft crashes on that day. This case highlights a very important issue, that the source of the fund for the reparation program need not be the wrongdoer. Therefore, while norms and laws do obligate the wrongdoers to compensate, a major thing that we need to keep in mind is we need to keep the victim and the needs of the victim separate from the need to hold these perpetrators accountable. In this case, the United States government decided to step in and help compensate the victims, despite the fact that there's no law that would have obligated, no international law, that would have obligated the US government to undertake such a large compensation program. But just as importantly, the probability that the perpetrators were going to provide for their reparations are next to zero. So these two cases provide important lessons for the situation in Lebanon, which I'm going to talk about. First, while reparations for violations of international humanitarian law are traditionally seen as within the realm of one state's responsibility to another with little room for the individuals, there has become more awareness in many cases. Either states are still at war with one another. As I mentioned before, the state has carried out the violation, does not acknowledge the violation, or the fact of the matter that they refuse to do so or are unable to do so. And if no action is taken by the third party, either the state whose citizens have been violated or international community, then the rights of these victims will never be addressed. And second, the idea of separating the needs of the victim from the need to hold perpetrators accountable by making them provide for their reparation has begun to get more attention within the international community. So as a result of this ongoing shift, where now today we're more willing to see other actors step in to provide for reparations, we argue that this is going to be something quite similar in the case of Lebanon. But then this brings us to a second question that I talked about. How do we provide the reparations for the victims? How do we provide the compensation when there's no agreement in place? And how do we undertake such a large program? And one thing that we argue in this paper is that we need to start looking at reparations and reconstructions in a complementary manner, not in an independent manner, which the literatures right now view them almost as if they were independent, with some exceptions for some scholars. Now, the tension between reparations and reconstruction programs is quite understandable. This is an issue that faces both situations where you have human rights violations, but also situations where you have international humanitarian law violations. That is, after a conflict, be it a civil war or interstate war, what you're going to have is a state that's very weak. Sometimes the state doesn't have the resources. Sometimes there's a total destruction of infrastructure, and the need to invest in political and judicial institutions. So as a result of this needs of the state, this is going to then lead to a tension between the groups or the individuals that are going to argue for reparations being paid to the victims who were targeted by the state or its agents or by other actors directly and violated their rights, and the need for the whole country to repair, to reconstruct, to rebuild. And so these tensions constantly exist. But if you think about it, at the end of the day, if you look at what the goals are of these two programs, it is about helping the country come back onto its feet. It's about making sure that the country does not repeat, or the victims are not victimized again down the road. And they're usually about building democratic institutions. Both of these reconstruction and reparation programs, for example, one element in common is institutional reform. How do we rebuild these institutions to make sure that violations do not occur again? And so, however, the main difference stems from sometimes the moral, okay, the reason as to why, okay? So with respect to reconstruction, this happens in most conflict, but sometimes you see those programs after an earthquake or after a tsunami, right? So it's not only when the violations have occurred. Whereas in the case of reparations, they are only in situations because there's a belief that there's a moral and political reason of why we should provide the reparations. Particularly, there's a belief that the survivors are entitled to reparations because their rights have been violated. If we think about in Argentina and during the Dirty War in Argentina, many people were kidnapped, many people were tortured for no reason, sometimes being at the in the wrong place at the wrong time. And so there was a huge, huge push to provide reparations for those individuals in that case. So while it is still important to hold perpetrators accountable for their crimes and what they did, donors can play a very, very important role by providing the funding, but also the technical assistance that may influence which post-conflict initiatives are implemented and how they're implemented. So third-party donors can help free up resources that government then could spend on the reparation programs. As I mentioned before, governments may not have those funds themselves. Therefore, by taking over some of the reconstruction and some of the development, the international community would at least make sure that reparations are a viable possibility for that state. So what about the Lebanese case? And where does the Lebanese case fit in all of this discussion? The Lebanese case is an interesting one, and I'll discuss in a little bit about what led to that situation. And we had victims in this case whose rights were victims of international humanitarian law violations. And since Lebanon and Israel are in a state of war, actions need to be taken to address the needs of victims, bypassing the traditional state-to-state framework. In order to accomplish this, though, the Lebanese government set out to institute a plan that focused on the complementary relationship between reparations and reconstruction. That is, given the level of destruction that was left after the war ended, the national government needed to ensure that roads and bridges were rebuilt, along with addressing the vital needs of the victims whose rights were violated. The Lebanese government was stuck between the moral obligations to recognize the individuals and the families of the dead as victims and not merely as persons whose homes were destroyed or needed medical attention, and the rebuilding of the country. So for those that are not familiar with the war began on July 12, 2006. Many Lebanese woke to the news of a Hezbollah cross-border raid from southern Lebanon that led to the death of 8 Israeli soldiers and the capture of 2. Back then, it was automatically assumed that this would lead to another prisoner swap between Israel and Lebanon, akin to the exchange in 2004, where Israel swapped about 430 Lebanese, Palestinian, and Arab prisoners for the 3 missing Israeli soldiers during cross-border raid by Hezbollah in 2000, as well as an Israeli citizen. However, this is not what happened. The raid escalated into war, which led to the destruction of bridges, homes, hospitals, industrial zones, power stations, roads, and water treatment. The majority of the fighting took place between Israel and Hezbollah, but the Lebanese army was engaged in minor clashes with Israel. The 34-day war left about 1,200 Lebanese civilians killed, over 4,000 injured, and 1 million displaced, which led Amnesty International to charge Israel with violating international humanitarian law. That being said, this war also left 43 Israeli civilians dead, 1,489 wounded, and about 500,000 Israeli citizens were displaced. Amnesty International also charged Hezbollah with violating the prohibition under international humanitarian law on attacking the civilian population as reprisal, regardless of what abuses the enemy may have carried out. However, since I do not have access to a similar study in Israel, I'm unaware what the government did with respect to the Israeli citizens who were victims of international humanitarian law. And so my focus is going to be only on what the Lebanese government did to its own victims and not what the Israeli government may have done to its own victims, since I'm unaware of any study that has carried that out. Now, wars are ugly, and death is inevitable. However, the international community has come together on multiple occasions to outlaw certain actions and attempts to curtail the violence and the harms that may be inflicted during wartime, particularly against civilians. Based on the resolution of basic principle, which I discussed or mentioned briefly a couple minutes ago, as well as other rules and norms, Amnesty International and other organizations called upon the Israeli government to pay reparation, as the majority of the violations against the Lebanese citizens, at least, were attributed to the Israeli Defense Forces. However, they also urged the Lebanese government to provide full reparations for the consequences of unlawful acts or omissions carried out by Lebanese officials and by Hezbollah, particularly in making sure that the Lebanese civilians were safe and were kept out of the conflict. Now, given the traditional framework that I just described, what would technically happen is that Israel would sign a peace treaty with Lebanon, and you would get an agreement between these two nations about what the compensation should be, and then the Lebanese government would then be in charge of providing those compensation to citizens. However, Lebanon and Israel are locked into larger part of the Arab-Israeli rivalry, with many states, including Lebanon, not recognizing Israel as a state. So while Israel and Lebanon have negotiated in the past, those have not been successful, and the possibility of bilateral agreement between those two anytime soon is not going to happen. So the Lebanese government was faced with this dilemma, on the one hand, that there's no way you can get compensation through that traditional framework method. But also, the Lebanese government was faced with another dilemma, and that is most of the victims, not all of them, but most of them were Shiites, and many of whom were supporters of Hezbollah and Amal, who at that time were in a political showdown with the Sunni prime minister and his party. Again, also they were faced with the problem that during the warfare, many Lebanese had charged the Lebanese government with the fact that it wasn't doing enough as a state to protect Lebanese interests and civilians against Israel. And so the government felt the need to try to put together a reparation program as quickly as possible, not only to address the immediate needs of the victims, but also to acknowledge their status as victims. This had several implications for the Lebanese government. First, they were concerned with the internal dynamics and volatility of the Lebanese domestic situation. And second, by acknowledging their status as those who were subjected to international humanitarian violations as victims, they were indirectly able to put, or an attempt to put indirect pressure on Israel, as Israel refused to acknowledge the violation. So this brings us to the question, so what did the Lebanese government do then? If it couldn't go down the route of getting reparations through a treaty, what was it going to do? Now, with over 130,000 homes destroyed partially or completely, and a quarter of the Lebanese population displaced, discussions for the need to compensate the victims began to emerge soon after the ceasefire was in effect. First, there was an aid conference that was held in Stockholm, Sweden at the end of August to help Lebanese government finance the reconstruction and rehabilitation program that needed to be developed to handle the damages that the country faced during the war. In October 2006, then Prime Minister of Lebanon, Mr. Faten Ghosn, announced that the Lebanese government would take full responsibility for helping the victims whose homes were destroyed, as well as those who were injured during the conflict. However, given the magnitude of the damages, with an estimated direct cost of over $4 billion and a further of $6 billion in indirect costs, the government began to look ways to speedy up the process and try to provide both reparations and reconstruction. So, as a result, the Lebanese government developed a project of rebuilding Lebanon, which had two dimensions. First, it set up a program to directly compensate the victims of the war, and second, it devised the adoption scheme, whereby individuals, institutions, or foreign states could adopt an area or a project and directly contribute to its reparation and reconstruction process. Now, with respect to direct compensation, the Lebanese government compensated for three types of harms, or three types of violations. Human indemnity, so those people that were victims or injured or family members were killed. Housing indemnity, and the loss of income, particularly in this case were the fishermen, because of the oil spill and the whole destruction of their, they lost their source of income. Now, in addition to the compensation programs, the Lebanese government had to also rebuild all the damages of the infrastructure, schools, roads, airports, rubble, debris removal. And so this is where the adoption scheme came in handy, because non-governmental organizations, as well as governmental organizations, international governmental organizations, non-governmental organizations, as well as states can then contribute. We had UN Habitat for Humanity in Lebanon, Danish Refugee Council, and played a huge important role in reconstruction. Also international actors like the EU, Iran, Turkey, Saudi Arabia, United Arab Emirates, and United States also provided grants and soft loans to the Lebanese government for the reconstruction and reparation. The total amount committed by 66 donors was over $2 billion US. Now, while the actors that I just mentioned worked closely with the Lebanese government and gave money to fund projects that the Lebanese government did, some other organizations and governments decided to take advantage of the adoption scheme model and to bypass totally the Lebanese government. For example, Qatar and Kuwait. They decided to independently work separately from the Lebanese government. Now, a major motivation behind the adoption scheme was an attempt by then Prime Minister Senura, a Sunni, to shore up his support against his main rival, Hezbollah. And many of the Sunni Gulf states wanted to support the Senora government and counter the threat of Hezbollah. In the traditional post-conflict reconstruction model, which is traditionally championed by a leading international organization in Western states, usually the reconstruction is more towards governance, more towards security sector reform. However, this is not what the Lebanese government needed in this situation. It needed to compensate individuals and help the country recover quickly, and so it allowed these third parties to have total control over the projects that they decided to choose to carry out. And given that Qatar carried out one of the most extensive projects and was one of the most effective at the Gulf states in the reconstruction, I just want to briefly discuss what it did as an example to show the translation of such an approach on the ground. Now, first and foremost, we have to acknowledge, of course, each actor has their own interests, right? Individual interests as to why they do this, okay? Many students here know, I'm an international relations scholar, so by heart we believe that each actor has their own interests, whatever those may be, and so nonetheless Qatar had similar foreign policy interests. Qatar for the last several years, in addition to wanting to bolster the Sunni Prime Minister, Qatar in the last decade or so has begun to take several initiatives of becoming a regional mediator. In fact, it played a major role in negotiations to get this UN Resolution 1701 between Israel and Lebanon. And this is part of a larger foreign policy strategy that Qatar has attempted to take on in order to enhance its standing and security in the international arena. Therefore, Qatar viewed the success of the reparation program as an integral element for its position in the region. So what did they do? They set up the Qatar Rehabilitation Program for South Lebanon. This administrative unit was in charge to directly provide the compensation. Like I mentioned, it didn't go through the Lebanese government. So immediately after the war, what they did is they chose 4 towns that they were going to do, all of them in the south. Khim, Aita Shab were the predominantly 2 big towns that they took up, and they set up an office in each town and hired local Lebanese company to perform the damage assessment. They didn't even rely on the damage assessment on the Lebanese government, because there was all these arguments that there was corruption and some people got favoritism. So it didn't even, which is not totally untrue, but I mean, so what they tried to do is to set up their own hire a local firm and had everything go through them. They then set up a 6-step process. The victims have to submit a reparation at their own local municipality, and they have to provide documents of proof that this is their home, this is their land, the deeds. And then the municipality put together the files for each claim, and then it gave them to this to the local Qatari office. And then the representatives of the local Qatari office would take a look at it and say, okay, these are the ones that we're going to provide claims, provide reparations for, and they then provided a list of the names, and if your name was on the list, then you can go and get your check, which from the, you obtain your check. Now, they did it in 3 processes. The first one was to kind of like remove the rubble, to fix if you needed to demolish, if the infrastructure was no longer stable, you need to demolish, all of that, and then you take a picture, and then you go back and you provide the pictures that you did do this. Again, they wanted people to use the money for rebuilding and helping out the destruction of their homes. And then what they did after that is they'll provide you with the 2nd check and the 3rd check. The interesting thing is, today we still have many Lebanese, many of whom who were part of the areas which were compensated by the Lebanese government, who claimed they did not receive their compensation, or not their full compensation, whereas Qatar not only wrapped up everything by 2009, before things began to break out with the whole situation in the Middle East, they had actually were revising and found out that, when they made the assessments in 2006, how much it would cost to build, let's just say the material, it was a certain value, but by 2009, many of the Lebanese had claimed, look, it tripled. And so actually they had begun to provide checks to compensate for that difference. However, with all the whole situation in the Middle East, they have stopped that. But this in a way demonstrates, There was also Barakat and Zik carried out a study of housing compensation, and the majority of the victims who received their compensation from the Lebanese government were unsatisfied, whereas almost 60% of the respondents that had a better view of Qatar's compensation program. This also opinion was, was shared by those who were injured. So the Lebanese government model of both direct compensation and adoption scheme, of course, has advantages and disadvantages. The adoption scheme was highly successful in that it allowed third parties to come in. I mean, in some cases, like for example, France adopted a bridge. That's a very limited. It was built pretty fast, and so in these ways, by helping in the reconstruction, you can free up resources that the government then can use for other issues that may be important. It also allowed in this way for the government to recognize the status of these individuals as victims without putting the international community, putting that pressure on the external and the international community. Because part of the problem, if you just claim it's a reparation program, then you go into were these violations true violations, or were they collateral damage? And the international community does not want to go down that road. By creating just a rehabilitation and recovery, they can donate this money without having to take a stand on the whole war. And therefore, then the Lebanese government can do whatever it wants to do with the money, or they can adopt that little bridge, again, without having to take a stand on the war itself. So that's a huge advantage that can help the government. However, some of the disadvantages, right? First, it allowed the victims to compare. So if you were unlucky and you didn't happen to be in those towns that were chosen by a certain actor, then you weren't compensated or wasn't done well, and you felt like this is, why not me? What did I do wrong? And so this created a huge problem and what some would argue secondary victimization to these individuals who already had losses, some of which are unimaginable. And so this created a huge problem. Second, third parties have their own agenda. I mean, again, we cannot deny that and should not deny that. And they could influence a decision on whether or not to choose a project and which project they were going to choose. In some cases, this always happens, is that third parties love to choose projects that are visible. Right? So you choose something that you can put this huge, that will be done quickly. You can put a huge banner, you can put your flag, take a picture, send it to your domestic constituency. See what we did, we helped out in a war so far away. And so, because in many of these cases, these are democracies, and these funds are coming from the taxations of the citizens. So it's understandable that this is what they want to do, but it creates dilemmas, because are they picking out the projects that are the most needy and maybe the most important things to do? And thirdly, problems can emerge if the parties are unaware of the delicate dynamics of the communities they're trying to help. For example, one international non-governmental organization that was working in Lebanon, between August and December 2006, they had 4 directors that were, succession of 4 directors between August and December, none of them who spoke Arabic, and none of them were briefed on the local context. So again, sometimes you can have these third parties coming in, creating more problems, unintentional consequences, let's just say. So, but that being said, several lessons can be drawn from the situation in Lebanon, particularly for international humanitarian violations that have occurred when there's no agreement in place to provide the reparation for victims. First, you can bypass this traditional state-to-state model. There are several examples out there, Lebanon being one, the Iraq-Kuwait situation being another, September 11 fund as a third, and there's others. So I think we need to make sure that the compensation of the individuals or the individual's need are placed higher than the needs of to hold perpetrators accountable. Second, if states are provided with an approach that allows them to compensate individuals rather than to have to wait for peace agreements, because most often what we find is when they do sign the peace agreement, well, guess which thing gets to be negotiated on? The victims, right? So the state would say, okay, whatever, it's all right, you don't have to provide all this compensation. So they ended up using the victims more or less as negotiation and bargaining tools, and so that impacts the compensation for them. But if that does not become necessary, right, there's another model to provide for them, then that makes states less likely to use their victims as a bargaining chip. Third, donations and funds can help states whose victims whose citizens are victims of violations of international humanitarian law foot the bill, and so they can help them take a look at other projects that may need to be done. And so with that, I will end it here and open it up for questions. Questions? Whoa. Maha. Hello.
So I was wondering if you could tell us a little bit about the state of